I'm Dan Jensen, and I'm an attorney here at Parr Brown Gee Loveless. I practice in the area of natural resources law, which is a rather broad category that includes oil and gas law, mining law, water law, public lands law, kind of a collection of those things. Well, split estate lands is just a common term that is applied to properties where you have a different owner of the surface estate and a different owner of the mineral estate. Most of the time that's not the case. One person owns the property. Under property law, you own your land to the center of the earth, and no one ever thinks about any division of ownership within that land. But as it turns out, in the West, there is an awful lot of split estate land where someone owns the minerals, someone else owns the surface. Most commonly, it's the government that owns the minerals, either the United States or the state of Utah, and a private owner of the surface. When that happens, of course, you've got different owners, different interests and objectives for those properties. That can sometimes lead to problems. The laws on split estates are evolving. They have been for some time. There's a very famous case that sort of started this trend in Texas, and it's a classic example. You have a surface owner with a pasture, and he irrigates that pasture with a pivot, a circular pivot that goes around and irrigates his property. The mineral owner comes along and says, I'm ready to drill, and if he puts his pump jack there to pump the oil out of the ground, the pivot's going to collide with the pump jack, and one of them has to defer to the other. Well, the court in Texas ruled that these parties need to mutually accommodate each other's interests, take reasonable steps to allow each of the two owners to utilize their property interest. And in that case, they ordered the mineral operator to construct a concrete cellar and place the oil well, the pump jack, down in this cellar so that it would be lower in the ground and the pivots could pass overhead. More expensive for the mineral owner, for sure, but they still could recover the oil, and the surface owner can still irrigate his field, and both parties turn out all right. That kind of mutual accommodation has become very much a trend. And in all the states now, when you see these disputes, that's where the courts tend to go. They lean very hard on the parties to cooperate and find a way where both owners can get the most out of their property interest.